I asked ChatGPT and Claude to both take a look at my case summary and tell me what the truth of the matter looked like. You're going to find some surprising results here, like I did, and then also hopefully see ways to prevent it from happening to you. If you're pro se in court right now, you're not going to want to miss this video. It was definitely eye-opening for me, and let's dive in. So my case started back in 2022, and I used both AI engines just to see if there would be any difference in how they think. And we have to understand that their thinking is programmed by a human, by many humans. The first question here, just to show, please review this case summary and create a summary reading between the lines and telling the truth of the matter. Also create a one-page visual graphic that tells the whole story efficiently and accurately up to today. So we're going to go through what it says. Then I'm going to give a clarification onto what actually is going on, and you'll see its response. Let's see here. Alrighty. So reading between the lines. Already going into the fact that it's a very high conflict divorce. This was never a clean divorce. It became prolonged. It became a prolonged control battle. I can definitely agree to that. And I'm not going to give you any information just yet. So we see here, emergency motions is looking at everything. Like, all right, one party, primarily the respondent father, is constantly chasing process. Okay, respondent, that's me. The petitioner is the mom. So we got requests for mediation, equal parenting time, and financial fairness. Repeated motions to compel disclosure, enforce orders, obtain records from school, daycare, communication logs. Motions alleging fraud on the court. Requests to reopen evidence, that is as of this past, I guess, 30, maybe 40 days. Attempts to delay final ruling due to DCF investigation. So I want to pause here just a little bit. If you're picking up what I'm picking up, there's already a slight bias against the dad in the AI. Let's go to the other one. I'm going to switch over to another tab. Here we go. Please review this case summary and create a summary reading between the lines and telling the truth of the matter. Also create a one-page blah, blah, blah. Okay, you see it's the exact same thing. It's going into it as well. What the docket actually tells us. This is a protracted, high-conflict divorce. Both of them can tell this right off the bat. Spans the course of 4 years of litigation. The petitioner came in organized and lawyered up. She's always had a lawyer. She filed with 2 attorneys, which is technically slightly inaccurate, but I didn't touch it. She had one attorney. That attorney withdrew and switched out for another one when they found out my attorney at the time was like, I'm not going to deal with that lady, and I'm not going to put up with you. You being the opposing counsel's attorney. So came in organized, lawyered up. Children were weaponized from day one. This is the part that is frustrating and stings, yet I take comfort in knowing that I'm not alone. The children were weaponized. But they're flipping it as if it's me weaponizing them. If you read it, within 4 months of filing emergency motions, we're flying over passport denial and potential removal of children. This escalated through 2023 into sole custody motions, school enrollment disputes, a motion to subpoena daycare and YMCA records and welfare check by Largo PD. Now, if you've actually been through this, you're already picking up what ChatGPT and Claude both missed. Let's continue on. Me repeatedly tried to slow up or stop the case. It's actually inaccurate. I was the one begging to get to trial. But I also did my best pro se to respond to many things. So we're going to see this go through. I'm going to shut up now because I don't want to tip you off to what I found. He filed for continuances, including one citing a pending DCF investigation. The contempt filings tell the real story. Contempt filings against me for, they're going to say, what is it? Abuses of mandatory disclosure. I gave everything. And on silly little technicalities, like, oh, you didn't submit it in this format. Therefore, we win. The end game was a non-jury trial held on March 2nd. One of the things I don't tell the AI, because I just didn't want to get too deep into it, is we had the same attorney for 4 years up until the day of trial, and then it switched to a different attorney. Come on. Bottom line, This case was where one party had consistent legal representation, clear strategic goals, and judicial compliance, while the other fought their process itself. The court's patience, evident in numerous denied emergency motions with the standard may set a hearing with notice language eventually ran out. So I'm going to go back to the other side as well. It's going to say essentially the same thing. Judge repeatedly denies emergency filings, not because they're wrong, not because they're inaccurate. What you'll learn later on when you're pro se is there is no standard for a judge to rule on when it comes to an emergency motion. What is emergent is not in the statutes. A judge decides on their own if your motion is emergent. That's what I learned somewhat the hard way, and eventually hopefully used it to tell a story and leave breadcrumbs. Now we changed judges, so that changed a little bit. But at the end of the day, those emergency motions get in front of the judge immediately, even if they're going to be denied. The case drags for 4 years due to mutual escalation. It's actually not true. I was clueless as to how to get to trial. I'm pro se. I'm just responding to everything, going along with the process, assuming this opposing counsel attorney, Ms. Belargin at the time, was actually going to bring it to trial. But they were terrified of it. They even said it in emails, threatening me like, hey, you don't want to get to trial. Anything could happen. Okay, I've already lost everything. I'm going to shut up because I'm not going to tip you into all of it. The case drags for 4 years. Motions, blah, blah, blah. Let's go to the end. Okay. So immediate aftermath. The fight is not over. I did file a couple motions. Basically, none of the statutes were honored when it comes to the presumption of 50-50 here in Florida, July 2023. That is now the statute. That is what we are to rule on. We got marital property that was not distributed evenly. Marital assets were not distributed evenly. And then the parenting time not distributed evenly, along with many, many other things. The truth of the matter, a high conflict, documentation heavy, procedurally aggressive custody and divorce battle where neither party trusted the other, and the court ultimately prioritized closure over perfection. Perhaps, and this was eye-opening to me, just to get this AI to look at it. Reason being is we know judges are overworked. We know a lot of them don't even really know the law as well as they should anymore. So they may even be inclined to do the same thing that I did. Let's put this case summary into AI and let AI tell me what to think without actually opening the PDFs, without actually opening the information and diving in. Here's the problem with judging a book by its cover, so to speak. More specifically, one side leaned into structure, documentation, and enforcement. That's the one who filed for divorce. That's the kid's mom. The other leaned into challenges, objections, and escalation claims. The court avoided emergency intervention, let the conflict play out procedurally, then cut it off decisively at trial. I'm going to skip past this and go to the point where I started to give it some clarity. Now let's see what happens. And I'll show you that the other Claude AI has clarity as well. Clarifying information. Petitioner was majority income earner after respondent ruptured his Achilles tendon in June 2019 and became the bedside caregiver for their daughter upon a leukemia diagnosis in April of 2020. All 100% true. And I purposely didn't put my name in there. I didn't say, hey, I'm the respondent. I don't want to lean it one way or the other, but the information does have to be disclosed. Petitioner purchased a house without respondent's signature in July of 2021. 100% accurate. Once again, the marital property. The deed says a married woman, and for her to be able to get around me not signing the mortgage, they sold or had a deeds. I guess you could say she paid for a deed for $10, and the previous couple gave it to her. And this is Florida. I've also still have the text messages of David Wing. It's either Wing or Ewing. I have to double check, but I'm pretty sure it's David Wing, realtor, with saying, hey, I'll give you $250 if you just come sign the thing. No lie, true story. You want the information, I'll give it to you. I'll give you the exact screenshot. But anyway, petitioner purchased a house without respondent's signature in July 2021 and unilaterally moved out of their apartment with the children. Accurate. Children were enrolled in daycare in Pinellas County, even though the mother still worked in Polk County for 2 more years. So the kids were in Polk County in daycare. Eventually, she takes them out without my knowing, puts them over in Pinellas County. I still, on the exchange days that she chooses to honor in the beginning phase, I still bring them to school on time, driving from Polk County to Pinellas. I had a job delivering pizza in the morning, working private security at night, just so that I could have time to be with my kiddos. Taking them to school is something you don't get back. But let's continue. No assets were divided, and petitioner initially requested sole custody in 2022. When she filed initially, she wanted everything, sole custody. And later on in the case, let me look at my notes for the docket, it was around February, a month out before the final trial, that they amended their petition. It's like, this is ridiculous. And the judge allowed her to amend the petition to where it no longer says full custody, but it says in the wording of the authority given to her, full sole custody. Nothing outright says, it says, oh yeah, 50-50, but mom has full authority to take the kids outside the country. Mom has full authority to get a passport signed. Mom doesn't have to tell dad anything, but dad has to tell mom everything. He has to ask for permission. He's not even allowed on the emergency contact card, and mom is petitioning to change the children's last name. 61.13 best interests of the children should have presided over that and should be still presiding over that. Respondent's attorney withdrew from the case after respondent asked why there was a contempt hearing scheduled he knew nothing about. So this attorney that I have, after I did my research after the fact, is notorious for withdrawing from cases without having done any work, when it comes to the point of kind of rubber meeting the road, actually getting to hearing, actually getting to trial. But I'm calling and emailing. It's like, hey, I need some updates. Hey, why haven't we filed the things that we said we're going to file? So initially, it's my attorney, Ashley Belargin, talks to him. She's nasty to me. She's nasty to him. He hangs up on her. It's like, I don't have to deal with this. He said, hey, I listened to her for 8 minutes. Just dig into me. Very first phone call, even my previous attorney's assistant was like, I've never heard him do that. Never seen him do it. So he says, hey, bully, you're not going to bully me. She withdraws. In comes a bigger bully, Mr. William Hale Kelly, who comes out of the bowels of nowhere. And I'll get into that a little bit later. With all of the the notice of unavailability that he files when it's time to actually do work. Anyway, we got these two together. My attorney has an association with the Freemason Society. This guy, I'm assuming, might have some association with that as well. He's a very dark individual. But then my attorney, veteran, this guy discloses he's a veteran. After they talk and have a, quote, long conversation is what I was told. Then, all of a sudden, my attorney is non-responsive, slow to move, doesn't really want to do anything. And this is where Holy Spirit is like, hey, you should check the docket. After at least over 30 days of me not being able to get in contact with him, I even called another attorney. I was like, hey, I think I need to switch out. Say, hey, go in there, just go talk to Alicia and see what's actually going on. Oh, I forgot about this. Oh, we kind of dropped the ball because we switched off between the two ladies, blah, blah, blah. Non-willful negligence is what I call it. Nonetheless, I said, hey, what's up with this contempt hearing? Oh, we thought the other side, was just going to drop it once you provided all the documents. I'm like, I told you I've already given you the documents. I've uploaded them to your Dropbox. Why didn't you tell me? And then later on, as we get closer to this hearing, it's like, hey, we're going to do this mediation for $3.25 an hour. I'm like, hold up, stop. We've already been through this many times. I'm the one that actually filed the motion, and you're going to see that here. I filed the motion to have mandatory mediation. Not mandatory mediation, but to have mediation. I filed that motion, turned into an order. It was passed. We tried to mediate multiple times. Even Judge Spota was like, we are not doing any more mediation. We're not going to do a parent coordinator. He's like, I don't even think Mr. Tynes has the funds to do that. We need to get this thing ready for trial. He's saying it emphatically like that in 2024. So, respondent's attorney withdrew from the case because as we get closer, he's trying to play the game with this other attorney. I was like, all right. I said we're not going to mediation. We've already done that. We're going to trial. 1, 2, 3, XYZ. This is what we talked about in the very first time that we met. This is what you said you would do. Let's go with that. We don't have money to play this game. She doesn't want to mediate at all. I'm not going to do that. So we get in our case management conference and, Your Honor, I'm going to have to withdraw. Not even talking to me, not playing anything. So you're in the position of, all right, do you let him withdraw or do you force him to stay? If you force him to stay, he can still do more damage. Like you've already done enough damage. Take your nasty behind and go. So that's why respondent's attorney withdrew from the case after the respondent asked why there was a contempt hearing scheduled he knew nothing about. Respondent was forced to remain pro se as no attorney would take the case. I shopped it around while trying to represent myself with the contempt hearing coming up. It's like, hey, here's what I got going on. The attorneys kept asking, what does this other guy want? Why is he acting like this? Like he's going above and beyond what's necessary. And then they start talking about my attorney. It's like, oh, yeah, he does that. He's overextended himself. He's got all these cases and this small little staff, and he can't really handle it. And instead of being honorable, he decides to take the money and run. It's like, hey, I'm all for paying someone what they're worth. I'm all for paying them for their labor. But if you're not going to do the work, you got to get the money back. So I'm going to show you, this is what I said here. Let's go to Claude. There we go. So blah, 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 blah. It talks about all of these awful things. And it makes the dad look bad until, see, it takes the picture, blah, blah, blah. Exact same thing. Now watch what happens, because this is what happens in family court. This is what happens in our lives, especially with the dads that don't know how to control their emotions in the beginning. This additional context changes the picture significantly. That's why I always say look closer. Let me revise the analysis with the full truth of what this record actually reflects. Now here's the part that might make you want to cry a little bit because it hits you in the heart. What this case actually looks like with full context. The narrative embedded in this docket is one of systematic procedural advantage, not because Joshua was a bad actor, but because Veronica controlled the resources, the timeline, and the legal representation from day one. That's what it's all about. When we're talking about coercive control, financial abuse, legal abuse, and just violations of due process, it all stems around who's got the control with the money. It has nothing to do with, let me say it another way. Winning your case has nothing to do with the money. I've learned that because I've seen people put in $20,000. I've seen them put in $250,000. I've talked to and seen and heard the testimony of folks who have put in $700,000 and get the same result. We can't blame the state. Oh, it's because they're in this state or that. Each state is slightly different. However, the judges are the ones that are making the decision. It is really messed up that we have no accountability for judges when judges aren't given firearms. Police officers are, but we can prosecute a police officer for excessive force and not doing things right, put them in prison, even though they've been given the authority, the lawful authority to take one's life. A judge doesn't have that authority. They have no firearm authority, but yet they're not held accountable for the simplest decisions. And when they are, they're allowed to keep their pension and just resign. I digress. Let's go into this. The financial power imbalance was manufactured, then weaponized. Preaching. Joshua's indigent status filing aren't the story of a deadbeat. They're the aftermath of a catastrophic injury. I had an Achilles tendon rupture 2 weeks after my son was born. My daughter was 2 years old. That removed him from the workforce, followed immediately by becoming the primary caregiver for a child with leukemia. My daughter also got a leukemia diagnosis April 24th of 2020. Veronica was the income earner, the primary one, by necessity of circumstance and because it was like, hey, I'll be bedside. You can still work during COVID right now. Remember, that's the COVID time. She could work remote. She's like, all right, you be bedside. So by necessity of circumstance, not by some prior arrangement reflecting her greater contribution. Yet that income position gave her the ability to retain 2 attorneys from day one. Not from day one, but once again, I didn't want to correct that. Get too heavy into the corrections. While Joshua cycled through one attorney who eventually withdrew under circumstances that raised serious questions and then couldn't find another who would take the case. The house purchase is the most legally significant fact in this case that doesn't appear in the docket. I'm telling you this because it's not a movie and I want you to have some type of empowerment when it comes to actually fighting back and positioning yourself better than I did. So the house purchase. Purchasing marital property unilaterally without the other spouse's signature. Then immediately relocating the children to Pinellas County while continuing to work in Polk County for 2 years. Appears to be the predicate act that triggered everything. It suggests the separation was planned and executed strategically. Absolutely, don't talk to them, but it was discovered with not only her twin sister, but her mom as well. The children's enrollment in Pinellas County daycare, while she worked in Polk County for 2 more years, is difficult to explain on any basis other than establishing physical distance from Joshua before the legal filing. I still took my kids to daycare. When they were with me, I would get up in the morning and take them to daycare. And they were crying, actually. I have a picture of my daughter. She soaked my arm in tears, and there was such anxiety with separating from dad. They've always been with me, especially my daughter. She's the one, when she was crying, she was born, she stopped crying for no one until she heard my voice, and I held her. And she makes this little open one eye and open 2 eyes, and she's looking at me like, you look funny, but you sound familiar. The emergency passport motion in July 2022. Now, not only has my mother and my sister, who at the time, they weren't beefing, now they are beefing with my kid's mom, was like, hey, she said she had to file for divorce to get the kids out of the country. Once again, from Eastern Europe. They've come from a communist background, a very clandestine mindset of everybody stick together even if we're hurting each other and it's wrong. Never cheated, never smoked, never drank, never beat her, never done anything to deserve it. Just said, hey, that's not the lifestyle I'm going to live. You got your choice. We'll share the kids. They need both parents, not just one. If Veronica had already unilaterally relocated the children across county lines without agreement, Joshua seeking to prevent international travel was an obstruction. Oh, now the story looks a little different. It was a father with legitimate reason to fear further unilateral action. Now the story is starting to sound clear. You see, you can't just look at it on face value and say, oh, well, the courts would do this, and the courts would. If you've never done any of this or you haven't been through it, shut up. And I say that respectfully. Just shut up, look closer, and actually read the documentation. And if you still refuse to do that, or you look at it and still have a different story, I'd say look at your own father-daughter relationship. Look at your own relationship with your parents. Because most of the times, just like in my case here, kid's mom doesn't have a good relationship with their father. Now, they might say that they do now, but if you dig into the past with the abuse and all these other things, you'll find out that answer is a little bit different. So the attorney withdrawal is the most troubling entry in the docket. It was an absolute setup, right? An attorney withdrawing because their own client asked why a contempt hearing was scheduled, a hearing the client didn't know about, suggests either a profound breakdown in communication or something worse. Either way, it left Joshua pro se against a represented opposing party who's very aggressive, unnecessarily, with 2 attorneys, and I would even debate that there are 2 attorneys on it because in the motions that he filed for things that he wanted, he's trying to include her attorney's fees. I stand on the American rule. It says, listen, you already paid for it. Call your losses, or whatever you want to call it. I don't call it a loss. You pay for a service and receive the service. Call it a quits and be done. Each party owns their debts. Florida courts are supposed to account for pro se status, but 256 docket entries over 4 years suggest that accommodation was limited at best. Listen, preaching. Pro se is supposed to have, but not necessarily guaranteed. Like, oh, you're pro se? Okay, you know what? I'm going to help you out here. Because we're held to the same laws, but we shouldn't be held to the exact same standard. That's stupid. We have the American with Disabilities Act. We don't make people who are in wheelchairs held to the same standard as folks who can walk upstairs. We don't make the elderly nor infants held to the exact same standards as someone fully capable. Now, I'm not in this because I want to be. I'm in it by necessity. You would think that the judge would understand that and have a little bit more leeway or, advocate for justice if that's in their mind and heart. No assets were divided. That's the truth. The bottom line, let's go right here. What the docket presents is a disorganized respondent repeatedly denied by the court is better understood as a medically compromised, financially depleted, legally underrepresented father who was outmaneuvered at every procedural turn, beginning before the case was even filed. I want to look at that right there. Now everything starts to change. Instead of, and here's the part that really hits, Joshua ruptures Achilles' tendon, leaves workforce. She becomes the primary income earner by necessity. And then it starts to say the reality of what actually happened. Let's take a look here. And this is the part that started to hit my heart. I'll let you see that. But looks like, and that's so important, what does it look like? Many of us are set up with reactive abuse. People who have traits of NPD paired with BPD. Looks like Joshua tries to prevent passport. The reality, father protecting children from further unilateral relocation. Looks like 51-page rambling custody motion. Reality, pro se father trying to restore contact with sick child across county lines. It's really not that hard if you ask the right questions and you just choose to look. Instead, many times folks are overworked and they choose to glance. You gotta look, gotta do your job. Looks like another denied emergency motion. Emergency enforce equal parenting rights. Still not getting equal time. Not getting equal anything. And when I was the beginning of pro se, not even understanding what that was, I'm like, okay, emergency gets it in front quicker, and this is serious. No. I also learned later that you can't have a temporary motion granted if you haven't had mediation yet. Because the judge would say certain things that were like hints towards the answer, but dude, don't hint toward the freaking answer, just say it. You're not helping me any more than the attorney. Here's something that you'll learn, at least in Polk County, there's a self-help line, but if the other side has an attorney, the self-help line won't help you. They give the advantage to the attorney. It's like, you have to talk to them. We can't help you. Say, hey, this is what I need to file, or that, or blah, blah, blah. They will not help you. So all of these things here really add up to a clearer picture of the truth. I'm going to show you on the ChatGPT side as well. Truth of the matter. The core dynamic. Respondent becomes physically impaired plus caregiver during a child's leukemia diagnosis. Petitioner makes unilateral separation move. You've heard this before. I'm just going to go down to the bottom and try to find the bottom line. Hard truth, uncomfortable, but accurate. The most important decisions in this case were made before the judge ever ruled on anything. Once the children were moved and settled, the case became about justifying the reality, not deciding it. Man, true. The respondent was likely fighting uphill from day one. I tried to reconcile. I tried to work on the marriage. I tried to blame myself because that's what she did. She told me it was all my fault. And when I caught her stealing kids' clothes out of my home, I realized, nope, this person's mindset is gone and they're still focused on the wrong thing, so you can't come over anymore. That's when I became public enemy number one. That's when she filed for divorce. The legal system did not ignore the conflict. It processed it slowly and then closed it. 100% accurate. So I hope you got to understand a little bit more of not only my case and what I'm trying to present here. I didn't even mention in the AI here the fact that we got a brand new judge who has not worked in family law ever, came from criminal, and she had to preside over a case that she had not touched or had anything to do with in the past 4 years of its being established and ongoing. So the things that the judge reserved on and tried to set up for later for him to judge on didn't happen. It didn't talk about the fact that there were orders that went forth and Mr. Kelly would constantly change the wording and misrepresent the characterization of what the judge said. So I finally was able to find a transcript, a court reporter that would work with someone who's pro se. Many of them say, kick rocks, we don't work with you guys. I had to pay up front, but I had them in our hearing so that everything that was said could be recorded. Changed the whole game of how the judge responded. Changed the whole game of how you can fight and stand.